everyone, Chris Lewis from Fox 47's Digital Newsroom, and today is a historic day in Michigan history. Yes, it is. And if you didn't know why, I have Shane Hilliard on the line with me, talking to me about the fact that he was one of the first lawyers ever to give oral arguments in front of the Michigan State Supreme Court in the 200-year history of the Michigan State Supreme Court, giving oral arguments on a Zoom call. Yes, a lot of us are doing Zoom calls. We're doing interviews in different ways. We're talking to people in different ways because of the circumstances we're in. But this is a historic moment. So Shane, thanks so much for being here today.
Oh, you're welcome, Chris. Thanks for having me.
I really want to understand a little more about the historical significance of this because, I know that all of us are using this technology in different ways now because of the stay-at-home order that we're in. But what is the significance of the Supreme Court hearing oral arguments now in this way?
The significance of this is considering the state our nation's in right now, with most states having stay-at-home orders. There's a lot of restrictions placed on businesses, preventing people from coming and going. The exception today being in the Supreme Court via Zoom. I'm in the office. One part of the significance is, in a good way, if there is going to be a silver lining to this pandemic, is the judiciary may find it very beneficial to be able to allow attorneys, clients, more access to the courts via Zoom, Skype, FaceTime. Although echoing what Supreme Court Justice McCormick said, these remote access isn't the end all be all. Today was my first appearance in the Supreme Court in Michigan, and I would have loved to have been in the building, in the room, to get the full effect of it. However, it doesn't take away that for the first time, like you said, in over 200 years, there's never been a remote oral argument in the Michigan Supreme Court.
Tell me a little bit about the case and why did it end up at the Michigan Supreme Court?
The significance of this case, it started in the trial courts in Ingham County, in the 30th Judicial Circuit. The case was brought by plaintiffs who held a mortgage, and they filed a foreclosure action. And the defendants in that case, the Voutsarises, relied on their expert witnesses and their attorneys to provide them pretrial consults, preparation, and eventually trial testimony. Based on that reliance on their opinions, the plaintiffs in that case ended up winning their foreclosure suit. Now, unfortunately, throughout the litigation, Mrs. Voutsaris was undergoing treatment and subsequently passed as a result of cancer. She passed away in January of 2015. So this case has been going on for a long period of time. The estate reached out to our firm, and we represent the personal representative of that estate in an action that alleged professional negligence or malpractice, if you will, against the experts for giving what we allege was negligent opinions that they relied on, which caused the damage. The trial court dismissed the action based on a long-standing doctrine, the witness immunity doctrine. Witness immunity has been around for centuries. It was based in the common law that came across the pond from England, saying that it was applied usually to defamation cases, libel and slander. It provided absolute immunity to witnesses who were to testify in the courts in England on those cases. And as the American justice system developed and has grown to today, Michigan, like many states, have held that witness immunity is absolute. What the estate did after the trial court dismissed the action is we filed an appeal to the Michigan Court of Appeals, arguing that the standalone case here in Michigan, Maiden versus Roswood, doesn't apply in our situation because we are looking for redress against our client's own witnesses. They weren't adversarial to each other, which is a big distinction in the case law that has been set here in Michigan. And the Court of Appeals agreed to an extent and said that expert witnesses who are retained by a party, and if they were to give negligent opinions and damage those who hired them, then witness immunity does not apply, which was a big victory. However, the expert witnesses and their attorneys chose to file an application for leave to appeal to the Michigan Supreme Court, which is the highest court in Michigan. Many have heard the term the court of last resort when they talk about the United States Supreme Court. Here in the state level, the Michigan Supreme Court is the end-all be-all. And when the Court of Appeals case went up to the Supreme Court decided that they wanted to hear more. So they ordered the attorneys to submit briefs based on the question the Supreme Court posed, which was, does the privilege of witness immunity extend to retained expert witnesses whom are sued for professional malpractice? And today, this morning, I had the privilege and honor of being before the Michigan Supreme Court with two other fantastic attorneys and arguing our sides.
I know that there is also historical significance depending on the outcome of the Supreme Court's decision. So tell me a little bit about that.
This witness immunity doctrine has been the law of the land, Michigan included, forever, essentially. It's been longstanding, witness immunity absolute. So depending on the Supreme Court's decision, if the Supreme Court was to rule in the expert witnesses' favor, they would overturn the Court of Appeals ruling and the case would be finished. However, if the Supreme Court rules in the estate's favor, my client's favor, then we have essentially created brand new law in Michigan with respect to witness immunity. And there would be new law that would say retained experts whom are found either by judge or jury to have had a duty, breached that duty, and caused some type of injury would be able to be held liable for those damages and not be able to hide behind this long-standing doctrine.